I've started recording it now. And Lucianne, I'm going to give you control. See if it works.
Nope.
Oh, well, worth a try.
It says you can control the screen. Oh yeah, I think it's, did I do that?
I just did it.
Oh, you did it.
All right, I'll stop.
Yeah. I don't think it's working.
No. A bunch of people are still joining, but let's go ahead and get started. Okay.
Okay.
All right. So, good morning, everybody. And thank you for joining us for this webinar. We're going to be talking about making housing work for people with disabilities, understanding reasonable accommodations and modifications. So, I will briefly introduce myself and let Lucianne introduce herself. And I also want to let everybody know that everyone is muted during the presentation, and you can write your questions or comments in the chat box. In fact, we'll be doing a couple of exercises with folks, and we would like you to use the chat box when we're doing those exercises. So that feature will be there. We've decided that if you have questions along the way, we'll pause and take those questions. I think the presentation is more interactive when we do it that way. So we'll go ahead. Oh, now you're controlling, Lucianne. Look at you. So anyway, again, I'm Diane Dressler. I am a consultant with the Maryland Department of Disabilities on their affordable housing programs. I've been working with them for a number of years and have been working in the state of Maryland trying to create affordable housing opportunities for people with disabilities for the last 20 years now. So it's been a while, been a minute. Lucianne and I have done this training together many times. I can't even remember how many times. So with that, I'll turn it over to Lucianne to introduce herself and get started.
Okay. Good morning, everybody. I'm Lucianne Parsley. I am an attorney at Disability Rights Maryland, which is the statewide protection and advocacy center for people with disabilities. I am the legal director there, but I started out as a housing attorney, still consider myself a fair housing attorney. And my organization, for those of you who, I'm going to try to go down here. Let's see if we can do that. Nope, I don't think so, Diane. I can't go down now.
All right, I'll go back.
What's going on?
There we go.
All right. My organization, for those of you who don't know, haven't heard of us, we used to be called Maryland Disability Law Center prior to about 5 years ago. We are the state designated, federally mandated protection and advocacy center for persons with disabilities. Every state has a protection and advocacy center. We've always been the one for the state of Maryland. And our job is to ensure that people with disabilities have meaningful access to their communities and programs that enable them to be part of their everyday life. And we work in a whole number of areas. So from special education to Medicaid advocacy, housing. I now do a lot of mental health advocacy, developmental disabilities, transportation, voting, etc. So I invite you to get to know us if you don't already. Our services are free. We're funded through federal grants and legal services, and are here to serve the community. So here's a roadmap for today's training. We're going to talk about the laws that protect the rights of people with disabilities in housing. We're going to think through reasonable accommodations and modifications and some common barriers and how to address them. Diane, would you go to the next slide?
I'm trying, hang on. All right.
All right, so just as a preliminary matter, why are we doing this training? Why is this important? Well, first, it addresses the history of segregation and stereotyping of people with disabilities that most people are aware of, but the history of our country and indeed the world with regard to people with disabilities is one of feeling that people with disabilities many times should be set aside, put in institutions, and that people with disabilities are not capable of being our neighbors and community members. So understanding that equal access and opportunity, which are required by our civil rights laws, will help people with disabilities succeed in obtaining and maintaining their housing. Many studies over decades now have demonstrated that people have better health and quality of life when they have safe, affordable, accessible, and decent housing. So knowing this information helps you be more effective at your job. Next slide, please. Okay, so I'll jump right in. There are three major laws that protect persons with disabilities. The first is the Federal Fair Housing Act, as amended. So the Federal Fair Housing Act was first passed in 1968, part of the Civil Rights Act, amended in 1988 to include disability. And since that time, 1988, when disability was added as a protected class, the majority of complaints that come to HUD every year alleging violations of the Fair Housing Act have been disability related. In fact, I saw, preparing for this presentation actually a couple days ago, that as of 2020, HUD was saying a full 60% of all the Fair Housing Act complaints it gets, and that are complaints based on any protected class, race, class, gender, religion, etc. 60% of them are for denial of a reasonable accommodation based on someone's disability, which is amazing. So the second law, which protects the rights of persons with disabilities, is Section 504 of the Rehabilitation Act of 1973. It covers housing that receives federal funding, and it requires greater affirmative actions to promote full fair housing for people with disabilities. Finally, the Americans with Disabilities Act, which does not specifically cover housing in most cases, but Title II applies to services that are funded by the state or local government, and covers housing that is funded by state or local government, actually brings it under Section 504. Title III covers places of public accommodation, such as leasing offices. Many housing providers, for example, have swimming pools or other places of public accommodation, even leasing offices open to the public, and are covered by Title III. Next slide, please. So what do these civil rights laws do for people with disabilities? First, they require affirmatively that housing providers do not discriminate. They also protect against disparate impact. That means neutral policies that have a disparate impact on people with disabilities because of how they are structured. Next, a refusal to make reasonable modifications or accommodations, which is really somewhat unique in civil rights laws. So more than just promoting or requiring equal access, they make illegal the refusal to make reasonable modifications or accommodations to afford equal access. Finally, the Fair Housing Act has a requirement for housing providers to affirmatively further fair housing. That's not only for people with disabilities, but for other protected classes. And it actually requires them, particularly providers that receive federal funds, but all providers, to affirmatively take steps to make housing available, allow people who may not have knowledge about housing opportunities to know about it, and to take other steps to make an equal playing field. Next slide. Okay. So again, as a preliminary matter, who is a person with a disability? It's not often super clear. The Fair Housing Act really has the definition we're going to go with today. It's any person who has a physical or mental impairment that substantially limits one or more major life activities, has a record of such impairment, even if it doesn't actually limit one or more life activities, or is regarded as having an impairment. So importantly, the individual does not have to be found to be disabled or a person with disabilities by the Social Security Administration. They do not need to be approved for benefits. They just need to have a medical professional verify that they meet that definition under the Fair Housing Act or the ADA. It can be a social worker, case manager, if that person has personal knowledge. The Fair Housing Act does exempt from its definition individuals whose sole disability is current addiction to illegal drugs. Next slide, please. Okay, so under the Fair Housing Act, it is illegal to refuse to sell or rent housing due to someone's disability, to make that housing unavailable or take it off the market, for example. Advertise housing as available only to people without disabilities. Typically, you'll see housing you'll see advertisements that say available to those who can, quote unquote, live independently. Sometimes 55 and older housing communities or assisted living, you might see something saying no scooters, or see certain policies that say no scooters in the dining room. Those are illegal. Under the Fair Housing Act, it's illegal to discriminate in the terms, condition, privileges of sale or rental. For example, requiring a co-signer or a case manager. Co-signer maybe in the case of someone who might have an intellectual disability or a mental health disability, or requiring a case manager. Refusing to make reasonable accommodations that are specifically requested, and refusing to permit reasonable modifications to the unit, meaning physical changes like a ramp or grab bars at the tenant's expense, and threatening, coercing, or retaliating against anyone for exercising a fair housing right. Next slide. So laws addressing physical accessibility for persons with mobility disabilities. So the Fair Housing Act does have a provision that concerns design and construction. It says that all covered multifamily units constructed after March 13th of 1991 must comply with the Fair Housing Amendments Act design and construction requirements. There are standards, there are federal standards for what that is. Section 504 of the Rehab Act, which, as if you'll remember from a few slides back, covers units, housing units that receive federal funds. Those regulations provide that upon substantial renovation of units, developments with 15 or more units, they have to be made accessible. So the standard under 504 is 5% wheelchair accessible units or 2% UFAS units. UFAS stands for the Uniform Federal Accessibility Standards. There's now actually a choice between using UFAS standards and ADAG. ADAG is the Americans with Disabilities Act. Disabilities Act accessibility guidelines and covered units under Section 504 can be made accessible pursuant to either standard. They're very close. So Americans with Disabilities Act Titles 2 and 3 include covered units receiving state and local funding upon substantial renovation, also common areas open to the public, have to comply with ADAG, UFAS, and be readily achievable for existing housing and facilities. So what does this mean? It means that some housing must have wheelchair accessible units in it. And for housing that is federally funded, that is existing housing, upon substantial alteration, renovations, they have to make units wheelchair accessible. So that's important to know, because oftentimes, even if you go to a property management company, they may not be fully aware of where their accessible units are. So it's important to know where those units are and to know that what the requirements are. Reasonable modifications. So we're talking about making requests for actual physical changes to a unit. Under the Fair Housing Act, those are at the tenant's expense. And if the unit receives federal funding, that means they're covered by Section 504 and the ADA. They're state and local units, or there are common areas, they must be at the landlord's expense because of the federal funds. Next slide. Ooh, I think I did it myself, Diane. Okay, reasonable accommodations. So this is a term of art, a reasonable accommodation, and it means a change in rules, policies, practices, or services to give a person with a disability equal opportunity to use and enjoy a dwelling unit or common space. Reasonable accommodations may be necessary at all stages of the housing process, including application, tenancy, or to prevent eviction. Nope. Okay. All right, so in housing, there are legal requirements for reasonable accommodations. Federal and state laws prohibit housing discrimination against qualified persons with disabilities. So straight up, you cannot discriminate. Also cannot treat someone less favorably because of a disability, either theirs or a family member. Reasonable accommodations require a housing provider to do more. They require changes to rules, policies, practices, or services, if necessary, to afford the person with a disability an equal opportunity to use and enjoy a dwelling. Examples are permitting a change in how a tenant pays rent, allowing an applicant to demonstrate in a non-traditional way the ability to comply with the lease and pay rent. And one note is there must be a connection or a nexus between the accommodation that is requested and the person's disability. So the example of that that I often use is that, for example, requesting a lowered mailbox in a housing development or in an apartment complex. If someone were to go into the property management's office and request a lowered mailbox, but they did not have a need for that. Maybe they have a mental health disability, and they would just prefer not to have to reach up. Well, there's no nexus there. If someone rolls in their chair and says, I need a lowered mailbox due to my disability, that is a clear nexus between the accommodation and the person's disability. All right, so I think I'm gonna go back up. There we go. Okay, so we've gone through all the kind of definitions, and I'm going to stop here and just do our pretest, which I should have done at the very beginning. But I'm going to ask people, could you raise your hand? We're not going to give the answers now, but just try to ask these questions if you believe yes or no. Okay, so the first question is, are all landlords required to provide reasonable accommodations for disabilities? I'd like to know how many people feel like, yep, it's all of them. If you would raise your hand. How many feel, no, it's just certain landlords that are mixed into different categories are required to provide accommodations?
We've got,
Should we?
yeah, I'm waiting for them all to make up their mind and raise their hand. We have 68 participants and 21 people are using the hand raise. 23, 26, there we go.
I missed a hand raise for the
Another
first.
spot.
Okay. Thank you, Renee. All right, awesome. We're going to answer these at the end. Second one is, do reasonable accommodation requests need to be submitted in writing? How many people say yes? They have to be in writing to be real, or to be accommodations that the landlord is required to respond to?
I don't know if people raise their hand 2 times, whether it
Can you take it off?
counts for that or not, but we've got about half the people saying they
Okay.
think it has to be in writing.
How many people think, nope, it doesn't have to be in writing?
Now it's gone down to 21 people.
Okay, awesome. How many people?
18, 17.
Okay. All right, I'm going to move on to number 3. Service animals. How many people believe that service animals need to complete a certification class to be approved?
It's going up.
How many say service animals are required to be certified?
We've got about 33 people saying they think service animals need to be certified.
How many people say, nope, no certification required for a service animal?
And we got about the same number. Well, about 21, 22 people say no certification required.
Okay. All right, number 4, can somebody other than the person with a disability make a reasonable accommodation request for them, for the renter, if the renter is the person with a disability or the tenant? How many people say someone else can do it on their behalf?
We got about 36, 35, 37 people.
Okay. All right. How many people say, nope, it has to be done by the person themselves?
That's about 18. Say that.
Okay.
17, 16, 15, going down.
All right, number 5, is there a time frame for when a reasonable accommodation request can be made? Does it need to be made within a certain time frame? How many people say, yep, it has to be done at a certain time?
We've got about 18, 17 around there people.
How many people say, nope, doesn't matter, it can be anytime they want to do it?
Hey, we're going way up.
Good.
38.
Okay. All right, number 6. There are 8, by the way. Number 6, does a reasonable accommodation request need to be made to the property manager as opposed to someone else, just walking around, a janitor, for example? How many say yes?
We've got about 37, 38 people, 39, 40 saying it has to be done to the property manager.
Okay. How many people say, nope, doesn't matter, as long as they work for the complex? Yep.
And we've got about 17.
Okay.
It can be anybody. 16.
All right, number 7, moving on. Are tenants required to pay for reasonable modifications to common areas such as laundry rooms and community kitchens? How many people say it's the tenant's responsibility?
14.
How many people say this is a landlord responsibility to pay for this?
We're going way up. 38, 40, 41.
Yeah.
There you go.
Anybody for it depends?
We got about 20 people saying it depends. 23.
And our last question, this is something that's changed recently. So if you've had this training previously, there may be some change there. You may be surprised. Is there a restriction on the kind of animals that can be emotional support animals or emotional assistance animals? How many people say, yes, there's some restrictions there? Can't be a llama.
About 36, 35.
Okay. How many people say nope? No restriction, can be whatever they like.
And we've got about 19, 20 people say that.
Anybody for it depends?
It depends is getting 15.
Okay. All right, good. So let's see if we can answer all these questions.
We'll answer them later. Yeah, well.
Yeah, not right now, but as we go. Yeah. All right, let's see. I hope I'm not. Okay, here we go.
Here we are.
Accommodation. We did that one.
Well, back one.
Back one. This one? We did this
Oh,
one.
we did? Okay.
Yeah. Okay. All right. Reasonable accommodations. Again, a reasonable accommodation is a change in a policy procedure. And it does not a physical change typically, although there is one thing that we'll talk about, but a reasonable accommodation, generally the cost is not on the tenant, even if the landlord incurs some costs. Parking spaces, signs, and restriping are considered reasonable accommodations. This is the one that's a little bit kind of makes you say, but HUD has sort of decreed that they consider parking spaces, signs, restriping to be reasonable accommodations, although it actually is a physical change. And by that, I mean someone asking for a handicapped parking space, someone asking for a larger parking space because they have a handicapped van that has to have space for the wheelchair ramp to come down for them. Those are considered reasonable accommodations. The tenant does not pay for that. Reasonable accommodations must be specifically requested. Sometimes we will get complaints from people who say the landlord knew. We have to ask. Must be requested by someone who is a qualified person with a disability. Require the accommodation due to the disability. There has to be that nexus that we talked about. And the accommodation must be necessary to afford equal opportunity or use of the housing. So the housing provider must grant reasonable accommodations unless there's an undue financial or administrative burden. All right. Reasonable modification is a physical alteration to existing premises to afford a person with a disability full enjoyment. So by that, we mean grab bars, ramps, widening doorways, lowering countertops. Reasonable accommodations under the Fair Housing Act. Generally speaking, the tenant must pay for them. That's because the landlord is not getting any federal funding. That's why they're only covered by the Fair Housing Act. There is one exception to that, and I still do see this situation happen occasionally. If a development was already required to have been made accessible under the Fair Housing Act. That is, it was built after the 1991. It was required to have all the units either on the first floor, or if there's an elevator building, all units in that unit to be accessible. Then it is covered by the Fair Housing Act, and that it is not the tenant's responsibility to make and pay for those accessibility modifications, because it should have been constructed to be accessible. If there is other federal funding involved, and often there is, when you're looking at a tax credit development, often there is other federal funding involved, particularly in Maryland, then it is required that the landlord make and pay for reasonable modifications. Interestingly, HUD has said in its regulations that a tenant-based housing choice voucher or other kind of rental subsidy that someone receives is not considered federal funding. So that means that just because someone has a voucher or other rental subsidy, that they can move from unit to unit, that the landlord is accepting that but is not receiving federal funding. That's a definitional issue that Congress created when they established the regulations for receipt of federal funding. One of the requirements in the Fair Housing Act is that, I'll do that in 1 second, Robin. One of the requirements that is in the Fair Housing Act is that the tenant may be required to put money aside in escrow to return the unit to its original state when they've made modifications to that. HUD has qualified that, saying the tenant may only be responsible for restoring the apartment to the original state when he or she moves out, if it impacts the marketability of the unit. Let's see if I can go up here. There you go. There was a request to look at this one again. Oh, I think we might have missed this one. So these are the examples: a ramp, grab bars, levered door handles, specialized alarms for vision or hearing impairments, a lowered mailbox, lower lights. So what HUD is saying, that is just because a landlord put in or the person paid for levered door handles, for example, or lowered light switches, it's not going to have any impact on the marketability of that unit. The person is not required to restore that. If it's something like lowering the countertops or pulling out the cabinets below a bathroom sink, that may impact marketability, and that may be required to be restored. Thank you for Robin for noticing that we missed a slide there. Okay, so reasonable modifications under the Fair Housing Act. Generally, restoration is not required if the person is widening doorways, installing grab bars, installing an accessible route to the sidewalk. For example, many people in garden style apartments, if they can use them for people with wheelchairs will use them, and they will use their sliding glass doors to a back deck or a back patio to as an accessible route in and out of the home. If you're installing an accessible route to the main sidewalk, that doesn't need to be restored. Tenants are required to make modifications to common areas. So that might mean a lobby, a kitchen. There's a community kitchen, for example. So if the housing provider is not already required to have made it to make it accessible, for example, it was built before the requirements of the Fair Housing Act went into effect, the tenant can make a modification request to make those areas accessible. And in that case, the tenant would be required to pay. The landlord can, of course, require approval of plans, and the contractor cannot require, that it be made in a more expensive way. The landlord must maintain the modification once it's made by the tenant. However, modifications used exclusively by the tenant are his or her own responsibility for maintaining. All right, so paying for modifications. This is often a very big issue in it, and it can be complicated. There are various ways to pay for modifications for tenants. So these are just a few. There's a really good home modifications directory that the Department of Disabilities maintains that we can direct you to. You can certainly look, there's Medicaid waivers that provide for some funding for modifications to help people maintain independence. There are local programs in several jurisdictions. CDBG stands for Community Development Block Grant funded programs. Local charitable organizations will often do things like make ramps. The Department of Housing and Community Development has a rehab program or accessibility for seniors. Right now it's limited to homeowners. I think we are going to make these slides available to people. Yeah, thanks, Diane.
Sure.
Yes.
I just wanted to add one comment real quick, Lucienne.
Of course.
Medicaid waiver information. Waivers often also have a service that provides an environmental assessment. So it can, for example, pay for an OT to come and do an environmental assessment to see what type of modification would best address the person's disability needs, and then may have the funding to pay for that. So those are two good services that work well together.
All right, I'm having trouble getting to the next.
That's probably because I used my keyboard.
Oh.
It's got this, hang on, I'll get there. Here we go. Why are you doing this, computer? Okay.
All right, great. So we mentioned a few slides back that a landlord under the Fair Housing Act, and this is also under Section 504, is required to make reasonable accommodations and modifications if they're needed, if the person can meet the requirements, that they're a qualified person with a disability, that the accommodation is required due to their disability, there's that nexus, and that the accommodation is necessary to give the person equal access to housing. The exceptions to that are if approving or making that accommodation or paying for that modification would cause the landlord to incur an undue financial or administrative burden, or if it's a fundamental alteration to what they do. So this has to be determined on a case-by-case basis. It's often difficult to meet. For example, a tenant who uses a wheelchair can't use the dumpster outside to dispose of his trash. It is required that tenants dispose of their trash and keep their units clean and trash free. That's a lease requirement in this example. The tenant is requesting that maintenance come and collect his or her trash daily. Does the landlord have to grant this accommodation? Well, HUD has said that this might be an undue burden for a small operation, a small landlord, but reasonable to do so twice a week and supply an inside trash unit, for example, in a place where the person can get there. In terms of fundamental alterations of the program, for example, if a tenant requested of the landlord, perhaps they might say, due to my disability, I can't drive, I'm requesting that you provide transportation for me to get to the grocery store. The landlord might be justified in responding, well, that would be a fundamental alteration of our program. We do not have to grant that. We are a housing provider. We don't drive anybody anywhere. We don't have to drive you. And they probably would be successful in that defense. If a landlord, however, had a mobility van or a transportation van and was driving tenants places, maybe not going to the grocery store, or had a van that was not wheelchair accessible, a request that that van be made accessible or take people to the grocery stores might well be determined to be within the scope of their operations. It has to be an individualized determination. So it's case by case. It's not on a overall policy basis. If the defense is met, though, and the housing provider does not have to do it, the housing provider must continue to consider alternative accommodations to meet the person's need. I will say with regard to financial burdens, that's often difficult to meet because HUD will look at and courts will look at the overall size of the budget, not just the budget that the landlord has set aside, for example, for maintenance. So it's often difficult to meet that. Diane, will you go to the next slide?
You don't have control again.
Yeah, okay. All right, section 504, as we said, if a landlord receives federal funding from HUD, it's typically from HUD, but other government entities, they are covered by section 504 of the Rehabilitation Act. It comes with accessibility requirements. So because of that receipt of federal funding, new construction or substantial alteration requires that 5% of the units be accessible to persons using wheelchairs and 2% for people with tenants with hearing and vision modifications. And I will say for substantial alteration, that requirement can be increased based on the need of the jurisdiction. For example, it's been shown that in Baltimore City, there are a higher percentage of wheelchair users than in many other jurisdictions. As a result, the Housing Authority of Baltimore City has been required to create 7% of their new units as wheelchair accessible. Section 504 requires that wheelchair accessible units be dispersed throughout the building to promote community integration. They cannot be confined to one wing or one floor. Section 504 also requires landlords to make other modifications upon request. For example, things that we talked about before, changing door handles to levers to make it easier to open the door, switching a refrigerator to a bottom freezer or side-by-side freezer to enhance a mobility, providing grab bars, for example, at no charge to the tenant. Section 504 also requires accessibility of non-housing facilities like the lobby, the mailbox, the laundry room, accessible a route throughout the entire complex. Even if the development predates implementation of Section 504, which is July 11th, 1988, The landlord may have to make modifications to common areas to allow equal use. So that is, based on individual requirements, the individual case by case analysis, and upon request by an individual with a disability. Okay, next step. Thank you. All right, as we said, even if a landlord is not able to grant a reasonable accommodation or a modification, there is this requirement to continue to engage with the tenant to see if there are other ways to meet his or her needs. They have to have this interactive process to engage in negotiation to find a solution. So if, for example, a tenant is requiring a fully accessible unit, but the provider already has 5% of their units fully accessible, there is not a requirement that they create another entirely accessible unit. The housing provider could engage with the person to determine, can something somewhat less than full accessibility work for you? Would you be interested in moving to the next available accessible unit, etc.? If there are several possible accommodations, the individual's preference should be accommodated, like I said, unless that would cause an undue financial and administrative burden. The housing provider may suggest equally effective alternative accommodations that they don't the individual is not required to accept them if they do not work for him or her. PHAs and recipients of federal funding have a duty to affirmatively further, as we said, that's marketing and outreach, analysis of policies and practices, all with the goal of fostering inclusion and eliminating discrimination. This applies to Fair Housing Act covered properties as well. It's somewhat harder to enforce than if the development is receiving federal funds. Next slide, please. Okay, so Maryland also has a Fair Housing Act, which is substantially equivalent to the federal Fair Housing Act. It does add some additional protected classes, for example, sexual orientation, marital status, gender identity. I will say that one of President Biden's newest executive orders is reinstating the HUD interpretation of the Fair Housing Act's prohibition against discrimination based on gender to include sexual orientation and gender identity. So that is a positive development for tenants. On the federal level, Maryland already had clear identification that that type of discrimination was already illegal. Maryland's Fair Housing Act is limited to multifamily housing of 4 or more units, provided that the owner is occupied. Multifamily housing with 4 or more units and housing that is owner occupied with 3 or fewer, that for some reason this looks so strange to me, but if there is housing that is 3 or fewer, it is accepted from the Fair Housing Act. If it's 4 or more, whether or not the owner is there, then it is covered by the Maryland's Fair Housing Act. Some jurisdictions have local ordinances with additional bases of protection. Actually, we need to change this because as of last year, we have a statewide law protecting against discrimination based on source of income. So this is primarily, this is receipt of a rental subsidy, like a housing choice voucher, that if a tenant meets all the landlord's requirements for things like criminal background or credit, the landlord cannot turn the individual down for multifamily housing due to their having a tenant-based voucher. So violations under the Maryland Fair Housing Act, complaints can be made to the Maryland Commission on Civil Rights. They must be made within 1 year. To HUD, they can be made directly to HUD within 1 year, 6 months for subsidized housing, and to local human rights commissions. Okay. So we tried to do a little chart here showing what law applies. So maybe we can ask some questions and ask people to raise their hands here to give some info.
And make a couple comments just real quick, Lucienne, sorry.
Yes, of course.
This is just the first page of a handout that's 3 pages long. So just to let folks know that there's more than what you're seeing here. And then there was a comment I wanted to make before I forgot about it, about 504 requirements, because Maryland changed its qualified allocation plan for low-income housing tax credit properties, I believe in 2018, and now requires that all tax credit properties funded from that point forward comply with 504. So, and that you'll get that information when you get this full handout, I believe.
Yeah, do we not, we don't have that in there? Okay, for public housing, and by public housing, I mean housing that is owned and operated by a housing authority or a local jurisdiction that is funded by HUD's public housing and public and Indian housing department. Is it covered by Section 504 of the Rehab Act? You can see here, yes, it is. And it's because there is definitely federal funding in there. It is covered by the Fair Housing Act. Accessibility requirements apply only to housing built after March of 1991. So accessibility requirements under the Fair Housing Act are pretty minimal. They're lowered light switches, raised electrical outlets, a path of accessibility for a wheelchair user throughout the apartment and complex, enough room in the kitchens and bathrooms for a wheelchair to turn around, and reinforced walls. So that's covered in public housing. Section 504, of course, would be much more accessible. It would require at least 5% of those units to be fully wheelchair accessible, much stronger accessibility requirements like lowered countertops, like underneath sinks and vanities, for there to be cutouts so someone with a wheelchair can push up in between there, and much greater accessibility. Certainly covered by the Americans with Disabilities Act under Title II of the ADA, because it's run by a government entity, covered by the Maryland Fair Housing Act, and exempted by Maryland has an accessibility code. The low-income housing tax credit program is the major way lower income housing is created in the US today, and has been for the last 20 years. It is housing that is available to people, typically working people, unless you have a subsidy. Most of the clients that we serve that are on disability benefits could not afford to live in low-income housing tax credits without a rental subsidy. Is it covered by Section 504 of the Rehab Act? As Diane pointed out, yes, for developments funded in 2018 and later pursuant to our qualified allocation plan. Accessibility requirements apply only to housing built after March 1991. Would have the required accessibility for Section 504 for those units built in 2018 or later. I will say lots of low-income housing tax credits have other federal funding in them as well, like typically home funding or other funding that would bring them under Section 504 even prior to 2018. The ADA requires programmatic access, application offices or leasing offices, contractual services, swimming pools, gyms, et cetera, if they're available to people in the general public to be made accessible, covered by the Fair Housing Act, Maryland's Fair Housing Act, and the Accessibility Code, unless Section 504 applies, which would be all the time now. We see lots of home-funded housing, which is federally funded from HUD, certainly covered by Section 504, et cetera. 811 Project Rental Assistance, PRA, is housing for permanent supportive housing for people with disabilities. In Maryland, that looks like units that are set aside to be rented to people with disabilities. They are covered by 504 because they are receiving federal funding. They are covered by the Fair Housing Act because they are all built after March of 1991. Certainly covered by the ADA with regard to programmatic access and application leasing offices, et cetera. Then there is something called PBRA, or project-based rental assistance, colloquially known as in-house Section 8. Very not built for new construction often anymore, but is often used as part of RAD to train the new HUD's new rental assistance demonstration project to turn public housing into project-based rental assistance or project-based Section 8. Certainly covered by Section 504, so you have to have the enhanced accessibility in there. And finally, the USDA rural development housing. Lots of Maryland's rural areas have USDA, RDA housing covered, of course, by Section 504 because of the receipt of federal funding. Fair Housing Act would apply to housing built after 1991 for first occupancy. Programmatic access under the ADA, application offices, all common areas open to the public and covered by the Fair Housing Act. Yes. Okay. All right. Go to the next slide, Diane. All right. These are not specifically reasonable accommodation slides, the next 3 slides here, but I thought they would be important to mention because of the COVID pandemic and their importance to people with disabilities. So the Centers for Disease Control, you may have heard in the news, has established a moratorium on housing evictions. It has been extended multiple times through March 31st of 2021. I expect it to go even later than that. It requires that landlords may not seek evictions based on failure to pay rent. If every person on the lease signs a declaration stating that they have lost income due to the pandemic or have another reason for not being able to pay for their rent due to the pandemic, they provide it to their landlord. There is a declaration that is available that tenants may use. I think HUD has now said that tenants can write their own declaration if they don't have access to the CDC declaration. Important to know that rent is still due and owing, so it will be accruing. Tenants do have to certify that that they will apply for any government assistance that is available to them. Evictions may be carried out for other lease violations, including criminal activity. I'm going to qualify that in a minute when we get to the next couple slides. But this is an important protection that the Centers for Disease Control enacted in order to stop the spread of COVID and the deaths the death toll that has come from people in congregate settings like nursing homes and shelters, and certainly many of the people that we advocate for, if they were to lose their housing, would end up homeless or in a nursing home or other institution. Diane, could you go to the next slide? All right, Maryland has specific protections. Governor Hogan issued an emergency order that prohibits Maryland courts from ordering the eviction of any tenant who can show their failure to pay rent was the result of COVID-19. Examples include losing employment, needing to care for a school-age child, being diagnosed themselves with COVID-19, etc. This emergency order additionally prohibits electric, gas, water, sewage, phone, cable, TV, and internet service companies from shutting off any residential service, customer service, or charging late fees. So there's additional information for that, but that's available from 211. And we're going to have a handout about this too for you. Finally, there is some COVID rental assistance that will be coming. Maryland has received its allocation, I believe, in January of over $258 million that will be distributed to local jurisdictions for rental assistance to prevent evictions. Because we've said that that rent is still due and owing, and that's going to be a problem. There's going to really be a tsunami, we're afraid, for housing, of evictions to be coming up. Many of the legal assistance providers, including Disability Rights Maryland, Legal Aid, et cetera, are getting additional funding to help with eviction prevention. So that COVID rental assistance can be used for utilities, et cetera, as well. Okay. So that's to be coming out, and we're gonna keep an eye out for that coming up. The CARES Act is for landlords that receive federal funding. It requires landlords to provide 30 days notice to all tenants prior to eviction. For example, if there is not a good cause provision in the lease and the landlord wants to not renew the lease, or if there is a good reason for the landlord to pursue eviction. So landlords may not charge fees, or penalties on late rent, so long as the tenant has filed the declaration. And by that, I mean the declaration 2 or 3 slides prior, or their own declaration that they've lost income due to COVID. Because the CARES Act does not expressly tie a notice to vacate to a particular cause for the eviction, arguably it prohibits, and some courts have already held this, that covered landlords may not evict a tenant for good cause. So that's just an additional temporary measure to keep people in their homes. Okay. All right, Diane, I think we're going to go to your part next.
Yeah.
Okay, great.
Okay. Thank you, Lucienne. Now hang on, everybody, while I get my video going back up here. There I am. Okay. All right. Thanks, Lucienne.
Sure.
And while I'm talking, Lucienne is going to monitor the questions. Again, if anybody has any questions along the way, just type them into the chat box, and we'll take a pause and answer the questions. So what I'm going to do with you today is, now that we've heard from Lucienne about what the laws are and some examples of how they can be implemented, we're going to talk about thinking through using reasonable accommodations and modifications to help the people you're working with be able to access, use, and enjoy housing like somebody who doesn't have a disability. On this slide, you'll see that reasonable accommodations can be requested and modifications can be requested at any time during the housing process. So that's from applying for housing all the way through ending a lease, or even through the eviction court process. So I thought maybe we'd do a little exercise to start out with. And if you would type your answers in the chat box, and we'll just take a look at what your answers are and try to summarize some of them. So, can you please type in the chat box an accommodation you think somebody might need during the application process? What might a person with a disability need as an accommodation when they're applying for housing? Just type in the chat box. Assistance gathering documents, access to the rental office, have the application read to them, filling out applications. We're getting more of that. Help with reading and writing, reading the signs, larger font, translator, verbal interview versus application. Excellent, all excellent answers. And yes, those are all kinds of things that might be needed by somebody when they're applying for housing. How about the resident selection plan? Are there any accommodations that somebody might need that are related to the resident or tenant selection plan? Now, that's the plan that says this is how this property is going to advertise their units, accept applications, review applications, offer units to people, all that kind of stuff. So alternate contact is good. Reading it again, somebody might need somebody to help them read the resident selection plan. That's good. And we'll go over some other examples as we go along through the presentation. How about searching for housing? What kind of help might people need when they're searching for housing? So a support person to help them go looking, a virtual tour versus a physical tour. That's going on a lot more now with COVID. Internet assistance, correct? How to search. They might need somebody to drive them. Transportation, a list of landlords. Okay. How about during their tenancy? What kind of accommodations do you guys think people might need while they're leasing their unit? So they've leased up, they're living there, understanding the lease, a change in the date that the rent is due. That's a good one, Robin. Yep. Sometimes people might need to request that the rent be due a little bit later because their benefit check comes the 5th of the month and rent is due on the 1st, and the landlord starts to proceed with eviction notices on the 6th. So they might need that kind of an accommodation because of their disability income payments. A hearing impaired smoke detector, live-in aid, correct, maintenance appointments, lowered light switches, cabinets, changing doorknobs, etc. Right, those are all things that people might find that they're encountering once they start living in their unit. How about for lease termination? Let's say the landlord has decided to terminate somebody's lease because they violated one of the conditions of the lease. Are there any accommodations that could be requested at that point? It's a tough one. OT assessment. Any other ideas? We'll go through these, so I'm not going to give you any more hints. How about during lease termination? I'm sorry, subsidy termination. The program has decided to terminate a person's ability to participate in the Housing Choice Voucher Program. Can somebody request an accommodation because of that? So maybe a support person to assist and explain what the program violation was, an opportunity to appeal, having a hearing, right? And then finally, during the eviction or court process, what kind of accommodation do you think somebody might request during the evictions process? Legal assistance, they might need to get legal assistance or representation. Interpreter. Okay, so let's thank you all for all of your answers. Let's walk through some of these points along the process and see what kind of accommodations we're generally talking about. So, common barriers for people to access housing include problems with getting on wait lists or staying on wait lists. For example, with the Section 8 program, often um, sometimes now housing authorities are saying that people need to reaffirm their desire to stay on their wait list once a year. So that might be a challenge for a person with a disability if they have difficulty with the cognitive processes, need to remember that, or difficulty accessing their email because of lack of internet access. Those kinds of things can be problematic. Um, Sometimes a housing authority will notify a person of their opportunity to apply for a voucher twice. They'll notify them twice in writing. And perhaps the person doesn't respond because they didn't understand the importance of the letter that they received. So those are all challenges. Missing documents is a big challenge, particularly for people who are in institutional settings. They may not have their birth certificate or social security card with them at the nursing facility or other institution. So accessing those documents can sometimes require additional time. Um, Inability to obtain documents. So getting bank statements or getting an updated social security award letter can be difficult for people, especially if they don't have internet access or can't get to a social security office. Um, Getting references, if a landlord requires references, can be difficult. Um, Access to searching for housing can be difficult if people don't have transportation or need an interpreter to do an interview. Missing deadlines is, I talked a little bit about already, because people may not understand the importance of the deadline or the importance of the letter. Credit issues can certainly be a barrier for people. We'll talk a little bit more about that in detail. And criminal background can also be a barrier, and we'll talk some more about that. So, this slide shows some reasonable accommodations in the application process and some examples of barriers. So, the barrier of vision impairment, a possible accommodation could be to provide an application in Braille or large print or alternative formats. If a person has a cognitive challenge or is not able to read, a possible accommodation could be to give them assistance with filling out the application. Lack of accessible transportation can be a barrier. So, an accommodation could be to have an application dropped off by a friend or a family member, or have it be mailed or faxed rather than dropped off in person. That could be an accommodation. Sometimes people with a disability aren't able to visit a leasing office because of their physical disability or lack of transportation. That can be very difficult to arrange. So, housing providers can, as an accommodation, visit the person at their home or nursing facility to complete the application. Requiring required documentation that's not ready available. We've talked about that being a barrier. So a person can request additional time to submit an application if they are having a challenge with getting that documentation, and that challenge is directly related to their disability. And then understanding communications, et cetera, can be a barrier. And having a secondary contact person listed on that application can be a possible accommodation. In fact, that's something that we often recommend, that people have a secondary contact person on any application for housing so that deadlines aren't missed. Somebody else is aware of what's going on and can provide assistance to the person with a disability in completing what's necessary in the application. So credit, as we talked about, can be a barrier. And sometimes people have poor credit due to disability related issues like medical bills or loss of employment. And a possible accommodation for that is to waive the credit requirement. So, for example, perhaps a person had a serious car accident and is now in a nursing facility and rehabilitation for several months. Perhaps they also had a head injury that resulted in a loss of memory. So they didn't remember that they were renting an apartment and therefore were evicted for non-payment of rent. That's a credit issue. Also lost their employment and don't have the income to pay for medical bills and other bills that they owed prior to acquiring the disability. And all of those credit challenges are related to the person's disability. So an accommodation to overlook those credit issues can be requested. Sometimes people aren't able to pay attention to bills or pay bills on time. Maybe they just the cognitive issues are difficult for them, or the treatment they're receiving isn't effective to help them pay attention to those kinds of things. So again, a request can be made to waive that credit requirement. And they can also get help from staff or perhaps through their waiver program, can get help from others to take care of their budgeting and their bill paying. So, some other challenges are criminal background issues. And sometimes people are denied housing because of the criminal background. But if the nexus or the relationship can be made between the criminal behavior and the disability, a reasonable accommodation can be requested to overlook that criminal behavior based on disability. So, some accommodation examples are that perhaps someone has a criminal background related to substance abuse, but they've completed a drug treatment program, have not engaged in illegal substance abuse or problematic behavior related to substance use. So they can request that that criminal background be overlooked because they've engaged in treatment and are no longer using the substance. Passage of time is another one. Sometimes criminal behavior may have been, 5 years ago, and nothing has occurred since then, and the person has received treatment for anger management or something. So that can be an accommodation to overlook the background on that basis. Um, some evidence from a healthcare professional, the person's being stable and in treatment, can be an accommodation. And sometimes people can request accommodation to overlook the background because they're now receiving supports from staff to help them maintain positive behavior. There are more staff involved, interventions on a more frequent basis, and that's helping to maintain positive behavior. So again, the request has to demonstrate that nexus between the disability and the criminal behavior or the activity. And there is a note that there are two instances that cannot be overlooked, and that includes a requirement for registry on a lifetime sex offense registry and conviction of the production or sale of methamphetamine on federally assisted property. So those are the two nevers. But otherwise, if the criminal behavior is related to disability, it's possible to think through an accommodation request for that. Assistance animals are often a topic that people talk about a lot with regard to accommodations and people with disabilities. And there has been, as Lucia noted, there's been a change in some of the rules from and guidance from HUD related to assistance animals. We're going to give you a handout with links to a number of different resources and a link to this new guidance from HUD on assistance animals is included in that handout that we will send to everybody after the webinar. But just some information about assistance animals. The fair housing definition of an assistance animal is an animal that works, provides assistance, or performs a task for the benefit of a person with a disability, or provides emotional support that alleviates one or more identified symptoms or effects of a person's disability. So, assistance animals are not pets. And pet policies at apartment complexes or that the owner may have in place do not apply if a person has a need for an assistance animal. And that's either an emotional support animal or an animal that provides a service, such as a seeing eye dog. The breed restrictions do not apply, and the additional pet rent does not apply, pet deposits do not apply. None of those things apply when a person needs an animal based because of a disability related reason. HUD doesn't differentiate between emotional support and service animals with regard to their policies. So they're all just, and that's been a change over time. HUD refers to all of these animals as assistance animals. Housing providers are required to accommodate non-residents who have service animals. So, for example, if someone has a visitor who has a seeing eye dog and the property has a no pet policy, the visitor has to be accommodated to allow the seeing eye dog to accompany them onto the property. This, I think we should probably change. It says it can be any type of animal unless the animal could cause significant damage to the property. As we've noted a couple of times, HUD has issued new guidance on this. Lucy, and I
Yeah.
know, yeah, why don't you step
So
in here and give us some
as
information
of
on this guidance?
January 2020, the guidance is that it must be a common household domesticated animal to be an assistance animal, and that if it is not, that there needs to be additional clear medical evidence that the animal is needed to either perform a task for the person or otherwise assist to the person, provide assistance to the person. So what that means is that, if someone has a capuchin monkey that provides service to them, does a task for them as a service animal, they would need additional evidence of that to be approved. There's a higher barrier. And with regard to common domestic animals, I noted that HUD talks about, hamsters and gerbils and cats and dogs all being included. I think it says in with regard to reptiles, small turtles. But Diane and I often would talk about people having a snake, and it seems that HUD has made it more difficult for that, even though I think there's pretty good evidence that some snakes have been found to be able to alert or let the person know if they're about to have a seizure. But to have a snake to perform that type of assistance for someone, you would need that heightened level of medical documentation. So that's a little bit of a change within the last year. I don't know if that will change under the new administration or not, but that's where we are right now.
Yeah, we usually get those questions about, can a person have, an elephant or a llama or something like that. And I think this new HUD guidance provides some additional thresholds for needing reasons to need those kinds of animals. And of course, there are other requirements that still do apply to a person who has an assistance animal. For example, The assistance animal has to be under the person's control at all times. It cannot inherently cause damage to the unit. So an elephant would be kind of heavy and probably too large and would cause damage to the unit. So, that might be an additional barrier for that. Um, and this other point is also a change within the last, several years, which is that an assistance animal can go anywhere the tenant can go. In the past, the rule had been that only service animals can go throughout the property. But HUD's more recent guidance has been that any assistance animal can go with a person anywhere on the property. So that's something to note as well.
So Diane, there's a question about miniature horses as service
Right.
animals. And this again is a change because HUD has said now that service animals are dogs.
Limited
So
to dogs.
limited to dogs. So a miniature horse is no longer permitted as a service animal. And I would imagine there may be some reasonable accommodation that might be made to that, but in
Mhm.
every other case, I would say no. We're going to give you a copy of the new HUD guidance. I think it's actually quite good and written in very easy to understand language, and I really like it. I'm still going through it, but it makes it clear that, for example, landlords cannot require housing medical providers to make their documentation of someone's need for an assistance animal under penalty of perjury, for example, which we had often saw, or that they say, I affirm and certify, or landlords were doing things that presented barriers to medical providers giving their I guess, opinion about whether an assistance animal is needed for a person with a disability. And I think in that case, landlords and medical providers were sometimes worried that they would be called to testify. So HUD has said, no, we're not going to be able, that landlords can't do that. They've also made it clear that the provision of a reasonable accommodation for an assistance animal may require also an accommodation to a zoning or land use ordinance, which is interesting too. So if somebody had an animal that would not be permitted under, typical, like in a city limits, I guess, having a certain type of animal, maybe a monkey, to provide assistance to the person, that might be required as well. It's very interesting.
Right. And breed restrictions, I think, may fall under that.
Exactly. Yeah.
There are jurisdictions that have implemented breed restrictions, particularly for dog breeds, and they do not apply to assistance animals. So I think this guidance helps to clarify some of that. So thanks, Lucianne, for that help. And as we've said, we'll send that guidance to you for you to take a look at. Um, Housing providers can impose reasonable requirements for health and safety with regard to assistance animals. So they can require that the animal be vaccinated. They can require that the animal be leashed. And again, it must be under the person's control at all times. And they can require that the animal waste be disposed of properly. So those are all continued requirements. They can't, as I said earlier, they cannot require pet deposits, additional pet rent or fees, and um, they cannot require the person to have renter's insurance if that is not required for everybody else on the property. So they can't be required to have renter's insurance simply because they have an animal on the property. Um, any expenses related to the assistance animal can be a medical deduction from income and therefore can lower the person's rent if it's a income-based rent program. So those expenses could be, food, kitty litter, leashes, obedience classes, vet bills, um, on and on and on. Any of the kinds of expenses that might be related to having an assistance animal or a medical deduction from income. As with all medical deductions from income, I always recommend that people keep receipts for everything they spent because they will need to demonstrate that they've incurred those expenses. So that's important. I'm going to pause for a second to see if anybody else has any questions about assistance animals, because often when we do training, this is a topic where there are a lot of questions. I'll just pause a sec. And I'm not seeing any questions. So if you have any along the way, just let us know. Okie doke. Now I have to make my computer work again. Hang on a sec. Okay, early termination of lease. This was one of those questions I asked earlier about what kind of accommodations might be requested for early termination of lease. So we wanted to let you know that in Maryland, there is a law that permits a person to terminate their lease early with a doctor's note certifying that the tenant needs to move. And some of those reasons for needing to move might include, let's say a person has an acquired disability. While they were living in the unit, they required a mobility challenge, and now they can no longer enter and exit their unit. So they may want to terminate their lease early so that they can move to an accessible unit. So that's permitted under this law. If somebody needs to move to an institution to receive treatment or a higher level of care, they may need to terminate their lease early. The landlord can charge up to 2 months' rent at the market rate as an early termination fee. So it's not necessarily without the incurring that 2-month additional rent that must be paid, unless, of course, the lease would end prior to that 2-month period. The lease may abrogate the statute by including an early termination clause. So the tenant can ask for a reasonable accommodation instead. If there is some part of the lease that abrogates this, then the tenant can request a reasonable accommodation to exit the lease early because of a disability related reason. And of course, medical documentation is needed. So we have a question. Would breaking a lease also be permissible if someone has a voucher, if medically necessary, to move to an accessible apartment outside of their current apartment complex? I think the request would be because of the medical necessity to move to an accessible unit. So if they're currently using a voucher in their unit and their unit's no longer accessible to them and they need to move, then they would be able to request that as a reasonable accommodation to exit their lease early because of that, even if it means moving outside of their apartment complex. I don't think. Go ahead.
I'm sorry, I would suggest that they probably need 2 accommodation requests. The first to the housing authority or the housing commission to move, to get a move voucher and be able to terminate. And then the landlord the housing authority will probably say you need some sort of permission from your landlord to end the lease early, because they typically do a 1 year. So then you would go to your landlord and make the same request. I have made when the landlord has refused and we're still negotiating or figuring out what to do next, I have just pursued with the housing authority and gotten a move voucher to move. for the individual, but I would suggest in that case, going to an attorney, a housing attorney. Legal aid does these cases, disability rights, to ensure that the person isn't incurring additional liability.
Thanks, Lucianne. Okey doke. So reasonable accommodations related to threatening behavior. Sometimes a person may engage in behavior at the property that's considered to be threatening either to neighbors or to the property manager. And then the property management company, the landlord, may be pursuing eviction because this is a lease violation. But the tenant can request, as a reasonable accommodation, additional time to comply with the lease. So, for example, perhaps the person has started engaging in threatening behavior because they're having a change in their medication treatment. And they may need more time to adjust to a new medication. And during that adjustment period, they're having some challenges with behavior. So they could ask for more time to receive treatment or for that treatment to become effective. They could also ask for an accommodation that based on having additional supports. So the person's having problems because it's really difficult for them to live alone. It makes them very anxious and they're engaging in threatening behavior. But their service provider might be able to provide them with additional supports, or they may have family or friends that are able to provide them with additional supports, have someone there with them more frequently, which can alleviate some of those behavioral and anxiety challenges. So that would be another accommodation, is to allow them to have more time so that they can receive extra support from family, friends, or their disability provider. The landlord does not have to grant the accommodation if the person poses a direct threat to the community. So, and that would be a particularly serious threat. The individual, and not necessarily type of individual or the type of disability an individual has, must pose the threat. So, for example, the landlord might say, well, it's come to my attention that you have a mental health disability and therefore you are a threat to this community and we're going to evict you. That would be illegal, because if that individual person has not themselves posed any kind of a threat, regardless of what their disability is, then that would be a problem. There's got to be direct, objective evidence of the threat, as we just really mentioned. General assumptions, subjective fears, speculation, etc., are insufficient to prove that the person is a threat to others. Now we have, I think, another question. For tenant-based vouchers through the mayor's office, would reasonable accommodation for breaking lease be made to the mayor's office? Lucienne?
Yeah, so I was just writing again. So the request is not really to break the lease to the mayor's office, but to get a voucher to move, or move your subsidy, end your subsidy there, for which that person is really a third party beneficiary, but it is a tenant obligation, typically a family obligation for that tenant to not move without permission and to continue to reside in that unit comply with the lease. So the request to the mayor's office would be to be able to move the subsidy to a new unit due to the disability. I think that, again, the mayor's office, similar to a housing authority, would come back and say you need to get permission from the landlord to end the lease early, which certainly can be done due to the disability. Sometimes the landlord doesn't understand the law and denies that. So you're stuck in a situation where you're fighting that separately and going back to the subsidy provider and saying, we're working that out, but the person needs to move now because it's an urgent matter. For example, they're stuck in their house now that they use a wheelchair. Thanks.
Thanks, Oceana. Okie doke. So ability to care for oneself or the unit. Independent living requirements are illegal. So if a landlord has some kind of a form or agreement or requirement that a person be able to care for themselves, that is an illegal requirement. The lease can only be ended if there's a breach of the lease terms. So the lease may contain terms that say that the unit must be maintained, it must be clean, free of vermin and garbage and things like that. And those are lease requirements that need to be complied with. But the person themselves does not have to be able to take care of those requirements. They may have supports through a service provider or through family or through paying for, housekeeping, etc., that might be able to take care of those lease requirements for the person. The housing provider must grant reasonable accommodations that would mitigate any kind of breach of lease that's identified. So let's say an annual inspection is done and the housing provider is saying that the person is not keeping their unit clean. The person may request additional time to come into compliance with the terms of the lease by bringing in additional assistance, bringing in somebody to clean or bringing in additional supports through their service provider, etc. Addenda or emergency contact forms that authorize a family member or a friend to end the lease or remove the individual from the unit may constitute disparate treatment based on disability. So if everybody at that housing complex does not have to have an addendum and an emergency contact that says that their family or friend can remove them from their unit, then a person with a disability can also not have that kind of contact form and authorization as a requirement of leasing. For example, limited power of attorneys prepared by the landlord, emergency contact forms required only if blind tenants or those in wheelchairs, etc. So those things are all illegal. So I think we've gotten no, we don't have a question related to that, I don't think. So reasonable accommodation to prevent eviction. Landlords can end the lease if a tenant has breached the duties under the lease. Violations can include not paying rent, not maintaining utilities. Maintenance of utilities is a lease requirement. And typically utilities need to be in the name of the tenant. Having unauthorized occupants. So most leases do not allow people to have other folks living with them that are not on the lease. Health and safety violations could end in termination of the lease or eviction, such as damage to the property or criminal activity, hoarding, unsanitary conditions, etc., threatening behavior, which we've already talked about. A lot of the properties that have been built more recently, particularly the tax credit properties, have no smoking requirements. So smoking on the property or smoking in a unit is a lease violation and can result in eviction. So some of the examples of accommodations that might cure some of these lease violations include getting some additional time to pay rent if not paying the rent is related to disability. So I mentioned earlier that perhaps someone's disability benefit payment does not come until the 5th of the month and they might need an extra day or two to be able to get that payment to the landlord. That could be an accommodation that's requested. As we've already talked about, participating in treatment to address a threatening behavior could be an accommodation that's requested. I will note that I did discuss smoking as a lease violation, and there are not examples of accommodations that can allow a person to smoke. It's not considered um, a, a, um, a condition that a person with a disability would be able to continue that someone without a disability would not. So on a non-smoking property, there's not an accommodation to allow a person to smoke. Now let's see. It said there's a question here. 236 properties have an in-house subsidy, I believe, so the request would be made to the landlord. That's from Lucienne. Is there a question here, Lucienne, that we want to
Yeah,
talk
the
about?
question was about 236 senior independent living facilities and are they illegal? And I will confess that I don't have a lot of knowledge about this program. I would say that what my understanding is that there can be no independent living requirements to entry, but these facilities, these programs don't provide meals or need not provide meals or other kind of services like home cleaning services to the tenants. That's my understanding of the situation. They should not be saying you need to demonstrate that you can live independently prior to leasing. They can ask things like, can you comply with the lease requirements to keep your apartment clean and trash free if they ask that of everybody who comes into the house.
Right. Thanks, Lucienne.
Sure.
Okay, so how do you make a reasonable accommodation request? Who do you make it to? Are there timeframes involved? All that kind of stuff. So a reasonable accommodation or modification request can be made by the person with a disability, so they can request it on their own behalf, a healthcare provider, so a case manager, a physician, a therapist, any healthcare provider could make the accommodation request on behalf of the person with a disability, and their family or friends can make a request on their behalf. So it does not have to be the person with a disability. Other people can make a request on their behalf. Who do they make the request to? Anybody employed by the housing provider. So we had that quiz question before, we're answering it now. A request can be made to the property manager. It can also be made to the maintenance folks that come around. It can be made to the administrative assistant at the housing authority office. A reasonable accommodation request can be made to anyone that's employed by the housing provider. Maintenance staff often get these kinds of requests. They might be in somebody's apartment fixing the dishwasher, and the tenant might say, "Gee, you know, I really need a grab bar. I slipped the other day because I'm unstable when I walk, and I need a grab bar." That's an official modification request and needs to be processed by the housing provider. When do requests need to be made? There is no specific time frame for making a request. So requests can be made at any time during the application, tenancy, and eviction process. Now, I will say, if someone is applying for housing at a property that's still being developed and they know they need some modifications to their unit, it would be a good idea for them to let the housing owner know that as soon as possible, so that, you know, if they're going to be leasing an accessible unit and they know that they need some additional modifications to the unit, it's a good idea to make those requests as soon as possible, especially if it's under construction, because it's less expensive for the housing provider to do it then. Also, making those kinds of modification requests, if they're known, um, sooner rather than later will help the person with a disability be able to use their unit better. But sometimes people don't know they need the modification until after they've moved in, and that's okay. They can make their request at any time through the eviction process, including when they're standing in front of the judge. How is the request made? We had this question earlier too on our little quiz. It does not have to be made in writing. A request can be verbal. We always recommend that it be made in writing because then you have documentation of exactly what you've requested and when it was requested, and you have documentation that was actually sent to the property manager or the owner in some other way. But it can be verbal. So that request that was made to the maintenance person of I need a grab bar, that was a verbal request, and that is considered a legitimate, reasonable accommodation request. Now, if a person is writing a letter to request their accommodation or modification, the letter should include a statement that the person has a disability, that the accommodation is needed, and how that accommodation relates to the person's disability. What is that nexus? What is that connection between what's being asked for and the disability? We are going to send you a sample reasonable accommodation request letter. So it'll sort of give you a little template to use when you're helping a person with a disability make their request. While the request does not need to be made in writing, the housing provider can request medical documentation that is in writing. So they can have a form that the medical provider, the healthcare provider, would fill out, and that is permissible under the laws, but not the request. The request doesn't have to be written. So documentation from a healthcare provider is typically needed unless the need for the accommodation is obvious. So for example, if a person is using a walker and they come to apply for an apartment, and I'm sorry, I had a little fly flying by here. They're applying for an apartment and they're saying that they need a grab bar in their shower. It will be obvious, I think, to anybody that this person uses a walker, they have a mobility challenge. So it would be obvious that they would need a grab bar. So having medical documentation of that is not necessary because the need is obvious. But sometimes people have a need for an accommodation that isn't as obvious, may have a hidden disability that would require an accommodation. So documentation from a healthcare provider can be requested. Healthcare provider is not just a physician. And I still see this. I had a recent example a couple of weeks ago of seeing that a housing provider was requiring that a physician fill out a medical form stating that a request was necessary. It does not have to be a physician. It can be a nurse, a social worker, a case manager, a therapist, OT, PT, somebody who has sufficient knowledge of the person's disability related needs to substantiate the need for the accommodation. So sufficient knowledge to substantiate the need. As I said earlier, the housing provider can't require the requester to use a particular form, but they can be required to use a particular format for medical documentation. Sometimes when people make the request, they submit medical documentation at the same time because they know it's necessary. If you're doing that with somebody, if they've got a nurse or an OT or a physician or somebody who is submitting the documentation, it should be on the letterhead of the healthcare professional so that, it shows the organization that they're working for. The person cannot be required to disclose specifics of their disability or copies of medical records or things like that. The healthcare provider's substantiation of the need is sufficient. So the housing provider can't say, well, you've said that the person needs this, but I need additional documentation to prove that from their medical records, et cetera. In fact, a lot of housing providers get a little antsy if somebody tries to disclose too much about disability because they know they're not supposed to get that information. So putting down information about a specific diagnosis is not necessary, including copies of plan of care is not necessary. Those kinds of things actually are, the housing provider usually doesn't want them. Now, do we have any other questions, Lucianne? Or is this
Nope,
still about the,
we're
okay,
still good. Yeah.
cool. So what happens after you've made the request? Um, First of all, the housing provider has to consider the request and respond in a timely manner. That's not been defined by HUD. I think housing providers that delay a response, of more than a month, few weeks, that could be considered a delay. And HUD has stated that a delay is considered a denial. So a fair housing complaint might be able to be submitted um, because the housing provider didn't respond in a timely manner. A written response is recommended from the housing provider. I think a written response is required. Isn't that, am I right about that, Lucianne?
I don't know, actually. I would think that to demonstrate that the request was responded to, it would need to be but I don't know. I haven't seen anything to say it's required.
Yeah, I think a denial has to be in writing. If it's approved, I don't think it needs to be in writing, but I tell you, if I was a housing provider, I would respond in writing just to show that I've responded to that. I've gotten concerns from tenants or case managers in the past where a housing provider has said, yes, I'll install a grab bar, and then months go by and it hasn't happened. So I think that the housing provider is best to do that response in writing so that they can say, this is when I agreed to the accommodation or modification request. If the request is approved, the response should provide a time frame for providing the accommodation. So it may be that, the person's requesting a modification to the unit that might take the housing provider some time to acquire the materials and a contractor to do that. So they should give the person a time frame. It's going to take me 2 months to be able to, get these materials in. I've looked at it. The supplier can't get them to me for 6 weeks, and then I've got to get on the schedule for the contractor. So, those kinds of things are real, and a time frame should be given to the person for providing the accommodation. And the housing provider can also propose an alternative strategy to meeting the need. So, a person may request a particular accommodation. For example, they may request that, you know, they may say that they're not able to use the dumpster. We'll use the dumpster example again. They can't use the dumpster. They can't reach up high enough and get the door open to get the trash in there. So they would like to have maintenance come twice weekly to collect their trash and put it in the dumpster. And the housing provider may say, as an alternative, we can provide you with a receptacle to put your trash in that's next to the dumpster that you could reach. So that would be an alternative strategy for meeting the same need. And as we've talked about before, this is a conversation between the housing provider and a person with a disability. It should be a back and forth, yes, maybe that would work. So it should be a process where there's discussion about what's going on. If the request is the denial needs to be in writing and they must give a reason. So years ago, I was involved in a request for an accommodation to um, a housing provider, and they responded in writing and the response was one sentence: your request is denied. And that isn't sufficient. They have to give a reason for denying it. Either, again, there are two reasons for denying a request, three really. It's not related to a person's disability. Um, the uh, the modification or accommodation requested is not affordable by the housing provider, or it's not something they do. So we gave the example of driving people to the grocery store, those kinds of things. So there has to be a reason for that denial. And even when the housing provider denies the request, they have to engage in a dialogue with the person to see if there are other possible solutions to accommodate the need of the person with a disability. If the denial is due to financial burden, the housing provider must explore when the work or a portion of the work can be done. So most of the time, a denial based on financial burden would be for a modification request. And the housing provider may say, we don't have the funds to be able to complete this work in 2021, but we might be able to do part of the work this summer and the next part of it in 2022 or something like that. Would that accommodate your need? So that's, part of the discussion that needs, or the dialogue that needs to go on between the housing provider and the person with a disability. The person with a disability also has the right to pay for all or part of the modification. So if they're not required to pay, let's say 504 requirements are in place, the housing provider is saying that this request is too expensive, the requester can say, I have waiver funds that might be able to pay for part of this. So if I can bring that financing to the table, is it then affordable? Again, part of the discussion. Do we have questions?
There are two questions.
Okay.
The first, I'm not sure I understand, but the first one was, we have a CFC waiver case manager insisting that a participant get a notarized lease from the person who's living with her friend. So the case manager was stating this will compromise her supports with the waiver. I think, I don't know why it would need to be a notarized lease, but I think that maybe the case manager is attempting to demonstrate to the program, the support program, that the individual is actually living at the address, at that address where they're receiving services. Diane, do you have any more thoughts about that?
That's my thought too. But I haven't run across anything that says that the CFC program requires a person to have a lease where they're living. So, if someone is living with a friend or family, they can receive CFC services. And I don't believe a lease at that place where they're living is a requirement of the CFC program.
Yeah, and then the second question was, if a person has a cognitive disability but fails to disclose it during the application process, then moves in and demonstrates threatening behavior, so neighbors are complaining and landlord moves to evict, then the tenant shows proof of the disability. Can this justify postponing the eviction? So I think this is a little bit complicated, but so first of all, the applicant is not required to disclose their disability ahead of time. Certainly threatening behavior may be a lease violation justifying the eviction. I'm not super clear here. Like, if the tenant shows proof of disability, that would in itself would not justify postponing eviction. Solely having a disability does not mean that you don't have to comply with your lease, for example. But if you showed that you were a disability and were a person with a disability and then asked for an accommodation, what we might ask, depending on the individual circumstances for the person, would be something like additional time for the person to get their medication stabilized or obtain anger management counseling services, or to get back into treatment, etc., that might justify postponing the eviction. If there was no way to mitigate the direct threat, then certainly they would not have to grant that accommodation. But if there is a way to mitigate that, then absolutely you would need to do that.
And that would provide more time for the person to be in compliance with their lease. But if the threatening behavior continues, despite the kinds of interventions that the person might have had, the housing provider could still pursue eviction.
Thank you for those questions. Yeah.
Okay, my computer went to sleep. Hang on. And then my screen. There we go. Okay, any other questions about how an accommodation request can be made? What's okay, what's not okay with regard to that? Okay, if you do, just type them in the box. This slide just shows some more handouts that we're giving to you. We've mentioned the reasonable accommodation request letter. It's just a little picture of what it looks like. We've mentioned the resource list, the list of websites that has additional guidance, that the COVID eviction moratorium information, the new guidance from HUD on assistance animals. Those are all going to be part of a handout. We also have a rental unit visit worksheet. This is just a picture of the first page of it. I think it's 2 or 3 pages long. And it's a series of questions that can be used by the person when they're taking a look at a place to live to see whether it's going to meet their needs. You know, is it a safe environment? Is the lighting good? Is the flooring conducive to me using my wheelchair? Those kinds of things are on that rental unit visit worksheet. So we'll send you that. And then there's a 2-page physical accessibility checklist. We have a picture of the first page of it here. And that's a tool that can help case managers and people with disabilities think through what their accessibility needs might be. Sometimes, as we've said, people don't really encounter the challenge with accessibility until they move into the unit, but thinking about it ahead of time can be helpful. And so we have this tool to help people think through those kinds of accommodations.
So Diane, there's another question, if I could jump in. It says, what can someone with a criminal background do to become eligible for the HUD 811 program in Maryland, the Project Rental Assistance Program? This is someone that has previously been denied for an available unit. So I think certainly a reasonable accommodation should be considered, particularly if the reason for the criminal history is due to the person's disability and is now resolved. So often we'll see people with untreated mental illness or substance abuse disorder that had criminal history that is related and is now treated and is no longer an issue. And that is perfect circumstances for a reasonable accommodation request. We also see sort of, it's not quite a reasonable accommodation, but is a mitigating circumstance. So perhaps someone had a criminal history in the past, criminal conviction in the past, and now their life circumstances are much different. Maybe they're much older now, maybe they're in a wheelchair, or they have MS, and that criminal history is unlikely to be a factor in the tenancy. That certainly a request can be made there. I will say, Diane mentioned this, that there are some types of criminal history, lifetime registration on the sex abuse registry is one. That weird one in public housing regarding manufacture of methamphetamine in public housing is another. that are not subject to reasonable accommodations, and that's by statute.
Right.
Happy to talk more about that though. with some of
Sure,
these.
and just with any kind of accommodation or modification request, keep in mind that you need to establish the nexus, the connection between the disability and the request. So if it's to overcome criminal background, the criminal behavior needs to be related to disability. I've had discussions with people who wanted to have a reasonable accommodation request for criminal background, but the criminal behavior happened prior to an acquired disability. So that, that would not be subject to the accommodation request. We're over time. I didn't even realize it until I just looked now. So I
Yeah,
want to thank you, everyone, for hanging in there with us. And thank you for the good comments here. I'm glad folks seem to learn a lot. Our contact information is here. If anybody has additional questions, please feel free to let us know. You will be receiving through Constant Contact another email that will have a copy of the PowerPoint and all of those handouts that we've shown you, including which law applies, the rental checklist that we talked about, the reasonable accommodation letter, the list of resources, and the accessibility checklist. So we thank you all for your attention. Also, this session was recorded, so we will send everybody a copy of the recorded session so you can view it in the future.
great. Thank you, everybody.
Thank you.
Appreciate it.
Thanks, Lucienne.
Okay, thanks, Diane. Bye.
Bye.